Judgment in the appeal Akers and others and Samba Financial Group.
This appeal concerns a subject of importance to the probably substantial number of people with beneficial interests in common law trusts holding assets in overseas jurisdictions where no institution equivalent to a trust is recognised. A challenge has been made to the very possibility of beneficial interests existing in such circumstances. The appeal arises on assumed facts as follows. Mr. Al-Sania agreed to hold on trust for the second respondent, Saad Investments Company Limited, SICL, shares in Saudi Arabian banks valued at around $318 million. SICL went into liquidation. The second respondents are its joint official liquidators. 6 weeks after SICL's liquidation began, Mr. Al-Sania transferred the shares to the appellant, Samba Financial Group, Samba. This was in purported discharge of personal liabilities he owed to Samba. The trusts were agreed under Cayman Island laws, but the shares are situated in Saudi Arabia. The law there, the lex situs of the shares, recognizes neither the institution of trust nor a division between legal and proprietary interests. SICL and its joint official liquidators contend that the transfers of shares were and are void under Section 127 of the Insolvency Act 1986. This provides that any disposition of the company's property made after the commencement of the winding up is void unless the court otherwise orders. Samba, in response, submits that the claim has no prospect of success. Below, and initially in the Supreme Court, argument concentrated on whether an equitable proprietary interest can exist in an asset cited in a jurisdiction which knows no such concept. It appears to have been assumed that if SICL had such an interest, it was disposed of by Mr. Al-Sania's transfer of title in the shares to Samba. The focus was on the Convention on the Law Applicable to Trusts and on their recognition, the Hague Convention, scheduled to the Recognition of Trusts Act 1987 of this jurisdiction. The Court of Appeal held that as Cayman Islands law, unlike Saudi Arabian law, recognizes the division of the legal and beneficial interests in shares, the trusts were arguably valid. After the oral hearing before it, the Supreme Court invited and received supplementary written submissions focusing more precisely on the question of whether there was any disposition within the meaning of Section 127, even if SICL had equitable interests in the shares and/or only enjoyed personal rights in respect of the shares by virtue of such interests. The Supreme Court allows Samba's appeal on the ground that there was no such disposition. Lord Mance gives the lead judgment, with which all members of the court agree. Lord Sumption, Lord Collins, and Lord Neuberger also give separate concurring judgments. The reasons are as follows. First, the court rejects Samba's submission that a Cayman Islands trust cannot exist in respect of shares situated in Saudi Arabia. On the contrary, in the eyes of the common law, a trust may be created, exist, and be enforced in respect of assets cited in an overseas jurisdiction, the law of which does not recognize trusts in any form. Nothing in the Hague Convention alters this conclusion. This is unsurprising, given that one of the Convention's aims was to provide for the recognition of trusts in jurisdictions which did not know the institution. Second, at common law, the nature of the interest intended to be created by a trust, and in particular whether it is proprietary or purely personal, depends on the law governing the trust, here Cayman Islands common law. In the present case, Mr. Al-Sania intended to create equitable proprietary interests in favour of SICL, but whether SICL's interests, as intended, were proprietary or personal, they constituted property within Section 127 of the Insolvency Act. But third, SICL's interest, whether proprietary or personal, was under English authority, which was not challenged on this appeal, capable of being overridden by Mr. Al-Sania's disposition of the shares to Samba, if that was the effect under Saudi Arabian law of the transaction between Mr. Al-Sania and Samba. Fourth, the critical and difficult question in these circumstances is whether the transaction between Mr. Al-Sanir and Samba involved a disposition of SICL's beneficial interest within the meaning of Section 127. Where an asset is held on trust, the legal title remains capable of transfer to a third party, even though this undoubted disposition may be in breach of the trust. But the beneficial interests remain. They are not disposed of to the transferee of the legal title. They continue to be enforceable against the transferee unless and until they are overridden under the law governing the transfer, here Saudi Arabian law. It can be argued that the concept of disposition extends to misappropriation of assets subject to a trust, even if this does not override any beneficial interest in the trust, or to the destruction or extinction of an equitable interest in such assets. But that is not in context the natural meaning. Where beneficial rights are overwritten, this is because they were always limited in their nature. The law regulates, protects, and circumscribes beneficial interests under a trust in a manner which is separate from and outside the scope of Section 127. For this reason, and not because of any doubt about the general efficacy at common law of common law trusts in respect of overseas assets, the Court holds that Samba's appeal succeeds. The parties have 21 days to make submissions on the consequences, in particular as to whether the proceedings should be stayed or struck out or remitted to the High Court with a view to their possible amendment to enable them to proceed on an alternative basis.